least for this first set of obligations on the collector and on the owner, pari material. You may not find it quote by quote, but essentially the person has dressed it up and put it in the form of rules where all those say, because I'll tell you why. The reason I'm making is I don't think the intention of the state as such, it was obviously the 2009 Act. The idea of the state was it was hopeful of having some regulatory exercise. I'm not suggesting that they were some, the state government. They were not acting. They were acting bona fide. But even when they were acting bona fide in 2009, the legislature, on the ground, it didn't yield anything at all, as this court has found. And putting this old wine in a new bottle and trying to market it ought not to pass muster. So this is the first point. Now let's go to the second set of, please go to page 6. Now look at section 4 earlier. Ensure that the bulls are put to proper testing by the authorities of the Animal Husbandry Department to ensure that the performance enhancement drugs are not administered to the bulls in any form and shall obtain a certificate to the effect in such form as may be prescribed. Ensure that the bulls are free of any disease, not intoxicated, etc. So this was 4, 6 and 5, 6 of the section. Your Lordship has page 6, serial number 2. Now the Your Lordships have page 6. So the left-hand side, left-hand column is 2009, correct? Now look at the rule 4 at page 6. Now look at rule 4 on page 6. Examination of bulls. The bulls shall be compulsorily subject to veterinary examination by qualified veterinarians of the Animal Husbandry Department. Now, obviously, Manoj, when the earlier act also envisaged, the word veterinarian may not be used, but obviously the Animal Husbandry Department personnel would be all vets. Otherwise, where's the question? Who? A general lay person in the secretarial staff has no competence to say whether there is nicotine, cocaine.
Quantitative difference from the earlier section 4 with what you have put on the right-hand side.
Right.
The earlier thing was see that are not administered any performance enhancement drugs, not administered, number 1. To ensure free from any disease. And
These are not a quotation. You should just know. I've asked them to paraphrase it. Just telling you, it's not a quotation.
That's right. That's right.
It's a paraphrase.
But if you contrast it with what you find on the right-hand side, they include both showing symptoms of fatigue, dehydration, restlessness.
Correct.
Shall be identified and not permitted.
Yes.
These bulls shall be examined specifically for possible alcohol and any for subject to any such abuse shall not be allowed to participate.
Right.
So it is more elaborate.
I agree with you. I am for a moment.
More elaborate and goes to detail.
So may I just answer that? May I just respond to that? First and foremost, it is not necessarily more elaborate in the sense that it was not covered earlier. So I'll just explain that. You might have had a particularization in the 2017 rules, which was not particularized in the 2009 Act, but it was covered by the 2009. Well, let's be.
The matter goes to substance.
No, I'll just
particularization itself is such that it knocks out the basis of the cruelty according to it. That, for example, if you see a particular bull, see, there are bulls and bulls. They may be trained, they may be fed.
Right.
Correct. But at the time when the actual fight takes place or the Jallikattu takes place, then the officer whom we have to pursue by statute ordains that he should perform a particular act. So that he performs his act. Let us assume that the act actually goes on well. That's one way of testing the constitutional law.
I agree, but that is, if I were arguing in 2013.
The bull showing dehydration, restlessness, identified, not permitted to participate.
Right.
So this was not there earlier. They were not.
No, it was very much there earlier.
No.
And I'll show you the corresponding provision.
Not there.
No, I'll just show you that. Just give you the equivalent to that. We'll give you the equivalent provision as well. So, Manoj, I want to just respond to that situation. You had rules in the form, rules in the sense, I'm using the expression in the form of detailed statutory provisions in the section under the 2009 Act, which corresponded to this. You're quite right. The word vet may not be used, the word Animal Husbandry Department may be used. But specifying a vet doesn't mean who else in the Animal Husbandry Department would know X or Y or Z. There may be some further, with the advance of science, for example, you may have a substitute of videography with a CCTV camera because CCTV cameras may be cheaper, etc. But that in itself is not a qualitative difference from the perspective of the bull.
Rule 5 you come to. That is very important. Rule 5 over the page, yeah.
Just give me a moment, please. Sorry.
Rule 5, if you in the meantime, if you may read.
Yeah, Millers of the new rules.
Yes.
Yes, yes.
Over the page, next page, page 7.
Yes, so may I just read that?
There is no equivalent in the earlier.
Yeah, that is so. Arenas shall be at least 50 square meters area. The bulls have to be embraced by the participants within 50 square meter area. The participants shall not be permitted to stand in front of the bulls as they enter. They shall also not be permitted to block the exit way for the bulls. The participants shall be permitted, etc., some 15 meters or up to 30 seconds or sustain 3 jumps of the bull. The participants shall not hold on to the tail horns using their hands or restrict the movement of the bulls by holding on to the bull's legs. The participants violating these guidelines shall be liable to be debarred.
Just pause there for a moment.
Right.
It's a matter of some moment because
Right.
you're talking about the flight response, the fear.
Right.
A large part of this fear can be attributed to the acts of the human being, holding on to the tail. Now, this is that part. We thought that there might be of some importance.
So I'll just tell you. Let me just tell
Knocking
you.
out the basis of.
So let me just the foundation of the previous judgment. Let me just explain that to you without reading any paragraphs. The idea, I'll just explain it to you in very general sense. So you have a bull. The bull is a domesticated animal. It is being, revered for the rest of the year, etc., and it does what a bull does. Now, at this stage, now it's a calm animal. We don't know what's passing through its mind, but it's sentient. That's what the science seems to suggest. It has a certain abilities over there in terms of pain, etc. Now, when it is put in an artificial setting, this is now the performance ring, correct? You remember that the performance was banned for all the circuses. That's why today our circuses don't have it, including insofar as bulls are concerned. Now we are coming to that, whether it's a bullock cart race or this. I am concerned, of course, with Tamil Nadu. Now, what's happening in this context is that suddenly the bull, from doing what it generally does, which is whatever, munching, eating, browsing, etc., it is put into an arena. Now, putting it in an arena itself may cause or trigger a certain panic by which it wants to leave the arena, but it is not able to do so. It wants to flee. The flight or fight response is that generally the bull will fly. It will try and leave, but it is completely barricaded and prevented. That itself is cruel. That itself is cruel insofar as an arena with spectators shouting, hooting, whatever, etc. So there's a panic response. Now I'll just complete, sorry.
Just when you say that.
Yes.
The second sentence of Rule 5.2.
Yeah.
They shall also not be permitted to block the exit way of the bull.
Yes, yes.
Earlier what would happen perhaps is
they
would surround it.
Yes, there is.
Create that flight response. So the human beings derive joy out of it. That is an animal right in front of us.
Of course.
That was the whole idea.
No, but
they have now made a change. The radical as it appears to be that they shall not stand in the way. They shall not stand in the beginning, that is in the entry point. They shall not block the exit. So they have made it a little bit, at least.
No, it's like participants, my lords.
I'm talking about the participants.
But who is to tell the bull? The bull, I'm just asking your lordships. The cruelty is because you have a large arena. I'm assuming there's a large arena. You saw some of the reports said there was no arena and it was being conducted in the village center, etc. Keep that aside. Assuming you have a large arena, it's not as if the bull can read an exit sign or something like that and say that this is the way out and I will follow that and someone is blocked. There is a huge, my lord, spectacle going on over there. We have shown you. Now you may have to go to the photographs and see how it's actually conducted. This is not a parade or something which you see while beating the retreat with the horses in a leisurely manner coming. This is a spectacle. This is an event. And it's an event intrinsically. Maybe you may want to condone it. That's another matter. But intrinsically cruel as far as it has been played out in the recent past. Because I don't know. We don't know what the tradition. But at least from 2009 to 2014, we have a final judgment of this court. 2017 onwards, we have a whole bunch of reports of this court. It is still played out in a cruel and what we term as an inhuman manner. Because of, as your lordship said, there's some sort of a contest. There is some people are trying to show their whatever notion of strength, etc. Because the bull itself is a notion of strength. But we believe that this is really, from any reasonable perspective, having a gate. Which, I mean, I don't think anyone is suggesting that the bull knows exactly where the exit is, etc. It's not really, it's cosmetic. Let me put it this way. These changes are, in my respectful submission, cosmetic, given the overall and given our experience. Why am I going into that? My submission is anchored on facts and on the basis of PETA reports. Anchored on the basis of those PETA reports, this is something which does not happen and the cruelty subsists. Now look at the next thing, point 4, the bull run area. Look at that. So earlier it was double barricade the arena or the way through which the bulls pass through in order to avoid injuries to the spectators. Sorry.
So they'll have to do the explaining. You can perhaps reserve your, if you wish to file a reply. I mean, make a
yeah, correct. So your lordships have gone through the
rest. Yes, we have seen.
All right, I'm very grateful. Thank you. So now, my lords, and we have mentioned some parts which are not there. Rest of the table. Fair enough? Okay. So essentially, I mean, in a line, this is a cosmetic change. Right? That's my urging. So
we
just give me a moment.
We have given you sufficient time.
Yes, absolutely.
More than.
Reported judgment.
In this case,
That's right.
as we will
So
demonstrate.
I'll just mention.
So, can we move on?
Yes. Well, I'm done. There's just sorry.
Cannot hold on.
I am done now. I'll just take 2 minutes. I want to answer those questions which were also put to me, and I'm see. Just let's look. I mean, I'm just stepping back from what has happened. The broad submission that I want to make in terms of the legislature's ability, and I'm going back to the point regarding colorable. Once this court has found that this is inherently cruel, can the state legislature, through an amendment to the Central Act, modify the mandate under the Central Act?
These are suspended submission.
In my respectful submission, I'm just looking at it differently. If the state legislature could do that, what's the effect is the question I ask. What's the effect? The effect is that a final judgment of this court, which can be only overturned by this court, without removing the substratum in terms of the factual determinations, etc., gets ultimately overturned. And that, I don't believe, is a permissible exercise, and therefore it is deeply colorable. Now, finally, the answer, can they not make a fresh legislation with safeguards? I have 2 answers. The safeguards were already there, and they were breached earlier. The safeguards introduced since 2017 continue to be breached, and therefore, in our respectful submission, there is absolutely no justification for sustaining this legislation. I'm very grateful. Thank you.
Thank you. Thank you. Who is going to argue?
Tell us one thing. You argued from 2 o'clock to evening. 4 o'clock yesterday.
Yes, I'm sorry. I thought I'll take half an hour.
Without taking a drop of water even. Not water at all, and you're going on continuously. Without even.
This species is not a sentient creature.
with no cognitive ability. I'm very grateful.
After such a long time, that he just either has some sip of water.
I think I should have been briefer. But thank you very much. It was a very pleasant.
So, at least you enlighten us on a different subject. Totally in a different way.
Very grateful. Thank you.
Youth power.
Yes, Giri.
Wait, please, Your Lord.
Yes, you are appearing for.
They beg to appear in the list of cases, my Lord, where different counsel are appearing. There are two writ petitions, my Lord, where I appear
For the petitioner?
for the petition. I beg to appear in writ petition number 25 of 2016.
25 of
2016. And then writ petition number 1193 of 2017.
25 of 2016.
16. Yes.
The act came only in
It
2017.
was amended.
You have subsequently amended it.
Yes. Then, my Lord, there is anyway
1193 of
2017. That, my Lord, squarely challenges this.
70. Okay.
Yes.
So both are in Tamil Nadu. You are in Tamil Nadu.
Yes, I am only in that. I am only in the Jallikattu.
So, see, the arguments have been fairly elaborately addressed by Divan.
My Lord, I will
tell
not.
you that, just need not repeat
No, no.
whatever is there. You can adopt the.
If your Lordships feel that I am repeating
No, no,
anything,
no, no.
Lordships may want,
That's
I'll immediately stop.
it. Correct. Need to go to Karnataka and also Maharashtra.
Lord, I am aware of it.
We just want to tell you that.
I'll not
If it's possible. So that.
Lord, it's only 15 minutes to lunch. I'll probably take half an hour to 45 minutes, not really.
That is, any new argument is there? Or?
Lordships may see whether there is anything.
Yes.
There is nothing new, Lordships may cut me short.
We don't want to cut him short. We want to give him full word. Is it not possible that in return, after the reply comes forward, you get clarity?
Lords, let me do it now because a reply might be necessary once they do. They may have to reply to something which I argue now. They may have to. I believe they have to.
All right, go ahead. Go ahead.
Master.
Lord, just the basics of the contours of what I with respect. Or the order passed, my Lord, in the review petition is really not one of the issues that come up for consideration.
Why files are not?
Correctness of the fine, sorry.
Files क्यों नहीं दे रहे?
Files दे दो.
WPC 25 of 2016 and WPC 1190 of 2017.
Two files. I think it has been. All right, then Lordships may kindly confine to 1193 of 2017. That is enough. I thought it was amended the earlier one, but your Lordships may confine to 1193 of 2017. That contains a frontal challenge to this. The earlier 2016, your Lordships are right. Lordships may ignore that.
So 1193.
No, I had also prepared on the basis
Not
of
this,
the
not this.
2017 petition.
Court master, not this.
If your Lordships have. Only the 2017 need to be.
1193. 1193.
1193 is enough. I'm sorry to have trouble.
Yes.
My Lord has to still get the files in.
No, we have not got.
Yeah.
My Lords have got the files.
I have got it.
Yes.
Yeah, tell us what you
My Lords, please note 3 or 4 dates, my Lord, which might turn out to be, my Lord, relevant in developing my speech. Nagaraj, my Lord, the judgment is delivered on 7/5/2014.
7/5/14.
2014. Nagaraj, my Lord, dealt with the competence and virus, my lord, of the 2009 Tamil Nadu State Act. And also when lordships have seen Nagaraj.
Yeah.
My lord, an application for review was filed by the state in Nagaraj,
Yeah,
which was dismissed on 16/11/2016.
yeah,
My lord, an ordinance which has led to the act in question
yeah,
was promulgated on 21/1/2017.
yeah,
And the impugned act is passed on 31/1/2017, deemed to have come into force from 21/1/2017.
21/1/17. Yeah,
No, my lords, the order in review passed on 16/11/2016 is not a non-speaking order saying that we don't find any grounds to review. The order, my lords, the learned judges will not go into the contention, they appreciate the contentions. And then they reaffirm the findings, my lord, given in the main judgment in Nagaraj, but also come out with certain other findings, my lord, which your lordships have seen. Some of them, my lord, I beg to place before your lordships. Point is, my lord, your lordships have always appreciated the difference between adjudicated facts and legislative facts. Adjudicated facts are facts, my lord, which are placed before the court. And, my lords, this honorable court adjudicates on such facts. They have a relation, my lord, to the parties before the court. Parties are heard on them. Conclusions, my lord, are arrived at on facts, saying that it has been established on facts that such and such is the state of affairs. Those are adjudicated facts falling strictly within the relevance, my lord, of an adjudicatory body. And especially so, my lord, they are entitled to a sanctity when the adjudication is done by the highest forum in the land. My lords, the facts which must have persuaded, my lords, the legislature in the earlier instance in 2009 to come out with an act, my lord, are broader. They are legislative facts.
yeah,
My lord, the challenge to the act in question was predicated on several, my lord, aspects,
yeah,
including, my lord, repugnancy under Article 254. That, my lords, that this violates, therefore, the provisions or it is in conflict with the provisions contained in the Central Act.
correct.
That this seems to be the argument of the state seems to be that this practice of Jallikattu is rooted in the culture and heritage of the state, which is peculiar to the state.
Correct.
And therefore, the organization of Jallikattu by itself, the organizing of Jallikattu by itself, cannot be treated as a cruelty, or the participation of the bulls in the Jallikattu as an event, and all such things which take place, my lord, in seeing that such an event is organized, will not amount to a cruelty
Correct.
within the meaning of the Prevention of Cruelty to Animals Act of 1960.
Yeah.
My lord, the nature of the animals, their essential characteristics, the fact that they are sentient animals, the fact, my lord, that they are unsuited to participate in an event of this nature, the fact that, my lords, that the actual organization of the event cannot keep at bay, my lord, acts which amount to a cruelty, subjecting the animals to unnecessary pain and suffering. My lord, I use the words because those are the words, my lord, which resound from the reading of the act. Is really has been adjudicated upon by the court, and the court says that no, this can't be done. But there is also, my lord, a finding of fact. These are adjudicated facts, my lord, by this honorable court, and it can't go higher than that. There is a reaffirmation of these adjudicated facts, my lord, in the review order. My lord, it's too late in the day, my lord, and I really cannot advance an argument before your lordships that the legislature is not empowered, my lord, to come forth with the law. If it removes the basis of the judgment, if it is otherwise legislatively competent, and, my lord, it does not violate any other constitutional provision, and more particularly, my lord, any provision contained, my lord, in part 3. The legislature is entitled to step in. It can remove the basis of the judgment. And in doing so, my lord, it therefore exercises a power, my lord, within its competence, provided it is within the legislative competence of the State. My lord, when it is challenged before your lordships will look at it from several angles, because the challenge is on the ground that it is not competent. Why it is not competent? Because, my lord, it strictly doesn't fall within entry 17 of list 3. A legislation of this nature, by which, my lord, the state brings about an amendment to the Central Act, carving out an exception, as it were, my lord, to the scheme that has been outlined with the Central Act, may not really fall within the competence of the legislature under entry 17. Why? I'll take your lordships to that. Secondly, my lord, if the legislature, when the law is challenged on the ground, then the legislature has usurped the judicial power or has transgressed into a territory which was occupied by the court's judgment, my lord, which has been rendered after hearing both sides, and a detailed judgment at that. Is there any factual material that is placed before the court, my lord, to say that these are legislative facts that have been assimilated by the legislature post the judgment and post the review order, which had persuaded, my lord, the state originally to come out with an ordinance, promulgate the governor to come out with an ordinance, and thereafter, my lord, place it before the floor of the assembly and then, sorry. Very,
Well, that's before my friend continues. Well, I just wanted to know what the lay of the land is. Well, after this, will Tamil Nadu have to respond, or are you going to hear Maharashtra and other?
We hear the round of the petitioners, and everything should be concluded by tomorrow. What we intend to do is, and we also intend to tell the court officer.
No. I'm talking about my response.
Should tell the registry not to put the alternate list tomorrow. Be over.
Right, Malad.
No, the whole of it. Otherwise, what will be, it will go on.
That's not possible.
The wholesome way of doing it is petitioner side is over, so the respondents.
I just wanted to know that,
What
Malad.
he's into do.
If that's what you're.
So you don't have to, if you were saying that you want to go somewhere.
No, it's not that, Malad. What is, there's a parted matter.
Today, because let them be over, that the petitioner side.
Well, I can reply tomorrow morning if your lordships give me a chance. I can reply in the morning at 10:30, Malad. If your lordships will allow me to do that.
Because in any case, the constitution bank will not say.
No, should not go against. I mean, we have no problem, but the lawyers are put in difficulty.
Lawyer doesn't know when this pen will collapse, not collapse. He's having a list of 40 matters on board.
That's an outrage. To you. This is not public.
I don't mind anything, Malad. I just want a chance tomorrow morning at 10:30.
Petitioners argue, your lordship knows, Mr. Luthra and Mr. Diwan have argued one, and they've not argued on dignity at all.
So whatever it is.
So we can finish by tomorrow, there's no
It
difficulty.
should be over today.
No, there are at least another 5-6 councils.
Whoever it is, they'll have to conclude today. This we cannot go on like that.
Very difficult, my lord.
You will have to supplement it with written submission.
Lord, it's very difficult to do it because this is a sui generis,
That's right, that's right.
a matter which is sui generis.
We have heard, we have.
Kind of several questions they have to answer.
Great respect, my lord. Judgment passed by this honorable court, my lord, was stayed by the Madras High Court, against which, my lord, Justice Panika Radhakrishnan himself has filed a petition which is pending before the three-judge bench. That also can be listed along with.
Whatever is listed before us, that is good enough for us. You argue, go on, otherwise we'll go on.
Lord, let me
Nagarajan,
go on
this
with.
matter goes to the root of the Nagarajan itself.
You go and you argue.
All I was saying is I should be given a chance. Oh, God.
We'll consider hearing depending on. Giri, go on.
Let me go on, my lord. Let me
Please, you
complete.
go on. We are telling you, we are not going.
Persons are this.
No, you go on, and you are also conscious of what we have said.
Yes. My lord, therefore, my lord, I thought,
Yes.
I realized, my lord, I did not convey what I wanted to convey correctly. It is not my submission that your lordships would be called upon to consider either the quantitatively or qualitatively the legislative facts which were there before the legislature, before they enacted this legislation. That is not my intention. No, my lords, that is not something which your lordships ever do. It is not done. The submission, my lord, is that every facet of, my lord, every facet of the aspect by which this legislation is sought to be sustained, either on the ground, my lord, my lord, repugnancy or absence of repugnancy, as the case may be, or that it is for the purpose of upholding culture and heritage of the state as such. Every fact of it, my lord, is not a legislative fact, but it actually has transformed into an adjudicated fact. That is what I want, my lord, to submit. Had it remained in the realms of a legislative fact, my lord, it
That
would
is already argued by Divan. Of course, you can supplement it. You can say.
I only supplement.
Inherently, it is cruel. We just articulate so that you can cut down.
No,
See
not
that
that.
it is the act itself is inherently
No,
cruel to animal.
That's not.
That it can never be done.
That's not
Whatever you may do, you cannot do it. So that is changed. That cannot be changed.
Just give me some time so that, my lord, I develop it and leave it. I'm not repeating whatever has been stated. Kindly bear with me for just 10-15 minutes. I'll just place this, and then your lordships may consider whether it is to be developed in more detail. No, my lords, please come to what I'm respectfully submitting is this. Please come to Nagaraj. The one fact, my lord, which will be put forth in my respectful submission is that this legislation seeks, my lord, to uphold the culture and heritage, my lord, of the state. Now, this was one aspect, my lord, which was pleaded as an argument on behalf of the state before Nagaraj. Or at any rate, it was considered and there is an adjudication on that aspect. I will not read it again before your lordships due to lack of time, but please take paragraphs 53 to 56 down.
That was sir.
Therefore, I am not reading it. Therefore, 53 to 56. Now, the preamble to the Act and the statement of objects and reasons says that it is to uphold the culture and heritage of the state, and that is why certain bulls are bred, and this is why the Jallikattu is also being held.
After Nagaraj, it is not available to them to say that.
That's what I wanted to submit. Because it's an adjudicated fact. It is not something, my lord, which will still remain in the realms of a legislative fact insofar as the legislature is concerned. There is a striking similarity between the statement of objects and reasons of the 2009 Act, which was looked into by Nagaraj, and the present enactment. But for the fact that this is now projected as an amendment to the PC Act, which is probably one way of saying that there is no repugnancy between this Act and the Central Act as such.
Therefore, what we thought was.
Yes.
You see, ultimate question perhaps might be.
Yes.
Whether in any form allowed or Jallikattu in a form cannot be done.
Lord,
Jallikattu, in other words, with safeguards which take care of the welfare of the animal involved, takes care of the human beings involved, whether the legislature in its wisdom, which normally we are subservient to, even in our judicial function, we do not say, no, we've got better wisdom.
No, you're not.
That is going to be the question.
Yes. No, my lord, let me respond to this. Jallikattu in a form that is modulated, that is regulated, or that is not possibly to be monitored in the manner as projected by the state, is it permissible? Or Jallikattu in all forms, whatever it is, or Jallikattu in all forms, whatever it is, as it should be banned, my lord, as Nagaraj has said. My lord, it's not a question which is it's not capable of, my lord, of one put it this way. Jallikattu sought to be regulated, or it could be, may not permitted, was put forth, my lord, in Nagaraj. My lord, why I keep coming back to that is because the Jallikattu by itself, my lord, has been the manner in which Jallikattu is to be conducted and why it is conducted These were all matters, my lord, which were placed for adjudication before the Honorable Court. It is not anybody's case, let alone the state. And that is to be reflected, my lord, from a reading of the legislation. The Jallikattu in this form is permissible. Jallikattu in this form was never the subject matter of adjudication by the Honorable Court early. Jallikattu per se, my lord, according to them, amend section 3, amend section 11.3, amend section 22, amend section 28. Jallikattu is therefore taken out of the purview of the PCI.
Along with the change in the rules.
My lord, rules are subordinate rules. My lord, the validity of the legislation cannot be tested or cannot be defended, my lord, by a reference to the subordinate rules which are framed by the state and are not legislative in character, in the sense that they cannot be elevated to the status of a plenary legislation. Question of repugnancy, my lord, arises. Question of repugnancy does not arise in the context of a subordinate legislation. Question of repugnancy always arises in the context of a plenary legislation. In the context, my lord, of the subordinate rules, the challenge is on the ground that either it is ultra-vires, or that it violates a parent statute, or it violates Part 3 or any other constitutional provision. Repugnancy question, a test of repugnancy always arises in the context of a plenary law. And that is what has been put forth.
Yeah.
My lords, if your lordships kindly come to, my lord, this is one aspect of it, and therefore, my lord, read with the rules as it now stands, or, my lord, which rules, according as your lordships were observed, pleased to observe, have made a seminal change from the rules which were there under the 2009 Act, will really not take the argument forward insofar as, my lord, the question of repugnancy is concerned. If the provisions of the Act, because after all, my lord, it is under the amended provisions of the Act that the rules are framed. No, my lord, if I want to challenge the rules, I can possibly challenge the rules. If I want to challenge, my lord, the conduct in which, manner in which, my lord, Jallikattu is now being conducted from year to year, specific instances, probably, my lord, I could do it. But, my lord, when I challenge the rules, and the rules are propped up by saying that these are not ultra-vires, the provisions of the Act, then, my lord, I'll have to show specific instances where the provisions of the rules have been violated. But that is not, my lord, an argument on repugnancy. In my respectful submission, 254, argument of repugnancy, judicial usurpation of judicial power, legislative usurpation of judicial power. These are all, my lord, have been laid down by your lordships only in the context of a plenary law versus a plenary.
Yeah.
Not in the context, my lord, of rules which are framed, subordinate rules which are framed, and, my lord, which have to be tested on the annual, which I just now, my lord, submit before your lord.
Yeah.
No, my lord, the further argument, my lord, I'm hurrying, my lord, because your lordships have said this. I just wanted to present what I respectfully submit would be a different facet to this. No, my lord, if your lordships kindly come to the PC Act, kindly have a look at the PC Act, my lord, the PC Act. Lordships have been taken through the objects and reasons of the main Central Act. When your lordships read the Prevention of Cruelty to Animals Act, your lordships would obviously have in mind entry 17 of list 3, which says prevention of cruelty to animals. That is what this act is intended to be. And that is what, my lord, it states in the statement of objects and reasons as well.
Yeah.
But please come, my lord, to section 3. Once your lordships read the main act, it shall be the duty of every person having the care or charge of any animal to take all reasonable measures to ensure the well-being of such animal and to necessary pain or is allowed to amendment which is challenged, notwithstanding anything contained in subsection 1, conduct of Jallikattu subject to such rules and regulations as may be framed by the state government shall be permitted. No, my lord, this is one. No, my lord, this by itself, my lord, would probably be inadequate. Therefore, my lord, they come to section 11.
Yeah.
Now, if your lordships have a look at section 11, 11.1 deals with treating animals cruelly. Each one of the subsections, my lord, of subclauses of subsection 1, beats, kicks, overrides, overdrives, overloads, tortures, etc., etc. Each one of them, my lord, has been treated as statutorily treated as acts amounting to cruelty. Each one of them.
Yeah.
No, my lord, then your lordships will come to subsection 3, because the amendment is in subsection 3. Amendment is not to section 11(1).
Yeah.
What therefore the Central Act behoves as acts amounting to cruelty in treatment of animals remains as treating animals cruelly.
One thing, sir, preparing for the state, is there power conferred on the state to make rules after the even your amendment?
Yes.
My lord, only subsection 2 or section
The amendment made to this main act,
By Tamil Nadu?
Tamil Nadu itself says that subject to the rules framed by the state government.
No. Whether section 38 deals with the rule-making powers being conferred on the central government. Have you amended the Prevention of
We have
Cruelty Act?
Yes, we have.
By which may be made on the rules may be made by the state.
Yes.
Where is it?
My lord, the Maharashtra has brought in section 38B.
That's right.
Tamil Nadu has not done. Therefore, my lord, they apparently would trace the source.
If you have not made amendment to the rule,
Section 3.
It's only under section 3(2) which says rules and regulations as may be prescribed.
But
But if your lordship says,
but
yes,
power is conferred under section 38 on the central government. By a central act.
And
It is
section,
in the concurrent list. Therefore, you
And
have
section
the
3.
power to amend the act.
and section 3, which has been added, but not amended,
Yeah.
that itself provides that the
No,
state
but that
can
doesn't
make.
confer the power to make rules on
doesn't,
it.
it doesn't.
It does, my lord.
I wanted to bring to your lordship's notice.
That does not confer power on you
Doesn't.
to make rules, which is why the Maharashtra government has in fact specifically amended it.
Yes.
And rule-making power must be conferred.
Lord, Maharashtra has amended.
Maharashtra, I think perhaps proves the point.
But both Karnataka and Tamil Nadu have not amended 38, that's all. That's what
If you don't amend the rule, how do you make the
Yes.
rules in the first place? And if you don't make the rules, the package with.
Lord, I checked up. I wanted to make this submission, but I checked up, Lord, the answer.
Section 3,
says so.
section 3(2).
3(2).
Yes, 3(2).
3(2), huh?
Notwithstanding anything contained in subsection 1, conduct of Jallikattu subject to such rules and regulations that may be framed by the state government shall be permitted.
All right.
Page Muller's 138.
That is true, that your lordships have seen.
That's what my lord asked, Muller. That's very much.
That is something which the lordships have already seen. Whether your
No.
lordships are asking whether
My lord asked
this
the
is a
question.
section analogous to section 38B of the
Doesn't
Maharashtra.
have to be.
That's not there.
Doesn't have to be.
Subject to such rules.
That may be framed by the,
state.
that's,
But where is the power to
Whether we put the power in 38 or not in either section, Lord, ultimately the power should be there.
that's all.
So that power has been reserved expressly and specifically.
Artfully done.
Yes.
Inartfully done, not.
My lords are right, it should have been there also, but with great respect, Lord, where the power is located would not be decisive.
Yes.
My lord, I have not reached it to the ground and therefore, my lord, I had not pursued it further. But this was something which. Yes, my lord. An ordinance for saying that August to the manner in which Maharashtra has. No, my lords, but when you. Nothing. My lord, A, the dehorning of an animal in the prescribed manner. Or such a determination or distribution for the time being in this problem. State ought to be the ABC rule frame. There are still other laws. Any matter within chapter 4 or, my lord, see E. The commission or omission of any act in the course of the destruction or the preparation for destruction of any animal as food for mankind unless such destruction or preparation was accompanied by the infliction of unnecessary pain or suffering. My lord, this clause has been the subject matter of a deep deliberation by this honorable. And therefore, my lord, there is a compendium of rules dealing with slaughtering framed at the state level and also framed, my lord, under the Prevention of Cruelty to Animals Act. Lord, I'll give it is all part of it.
Does it sort of harmonize
Yes.
with the injunction in the Upanishad that no being can claim superiority over another
Yes,
without claiming superiority. Obviously, you can't catch hold of whatever animal it is.
yes,
I mean, kill it, whatever is the cruelty involved, cook it, eat it.
eat it.
So when you're talking about animal rights,
Yes,
be reminded that even the lawgiver
yes,
has contemplated, in a manner of speaking, giving a slightly higher place to a human being. We have subordinated even the lives because we are not cannibals. For example, you don't kill a human being. In case that's what you are like some of the countries in perhaps in Africa, even some parts of Africa, they still have it. So we don't do that. But animals are allowed to be cooked for medicinal purpose. You can do that. In various stages, we'll find that animals are not treated on par with human beings.
this is what I wanted to submit. This is where, my lord, I would respectfully request your lordships to kindly consider this aspect. Subsection 3 of section 11 and subclause E. Therefore, my lords, permits slaughtering of animals for food. The other subclauses, my lord,
Slaughtering for the purpose of human, my learned brother pointed out, for religious purposes, you can slaughter it.
no, religious purposes, my lord, it has not been upheld as part of Article 25. It has not been.
It has been. It is, for example, in Uttarakhand.
Bakri, my lord, Bakri,
She
it has
was
not
there
been,
as a
it has
parting
not been
person, I
upheld
remember.
under Article 25. But assuming, my lord, that it is, assuming that it is upheld, it still would be, my lord, part of
Bakri
Article.
alone in whole part of Eastern India is
In-
animal sacrifice.
In all the temples,
Sacrifices, my lord, are prohibited. Animal sacrifices have been prohibited under a separate enact.
animals are being killed, lambs are being killed, offered as sacrifice in the temples in Uttarakhand.
Prohibited activity. It's a prohibited activity.
It was in fact considered by a division bench to the, and all that we said was, the division bench said was, it should be done in a slaughterhouse.
Lord, that part of it I understand. Lord, if it is done in a slaughterhouse.
Anyway,
then
the
it
act
comes-
says so, the act says so.
Correct, my lord. Nobody
Act
must,
says so.
nobody might have challenged.
What
that's a
you're
different
saying is
matter.
the general refrain is that there is a perception that animals are being subordinate to our interests. When you say you can't do it, means you can't do it. That animal has got the equal rights.
No, that's
Maybe
what
it
I-
is not
That's,
correct.
that's what I wanted to submit. Therefore, there is a subordination. But why is there a subordination? And why is the subordination not illegal? Because preparation, slaughtering of any animals for the food of the man, again, my lord, is probably propping up the fundamental right of man, my lord, to live under Article 21. It is traceable to Article 21. Therefore, subclause E could be upheld because, my lord, it is in perpetuation or it is in support of the right of man, my lord, to have food, which is part of the right under Article 21, right to live.
Why can't man live on land?
No, it cannot, my lord. It's a personal choice. That's a different matter, which is again, my lord, construed as a right of under part of Article 21.
Therefore,
My being a vegetarian or a non-vegetarian is my choice. It's part of my right to privacy. It is part of my right of choice, and therefore it is again be treated as under Article
how
21.
do you show compassion to the animals by killing them?
No, you do not show, but you do it out of necessity, and this is what has been considered, my lord, in Nagaraj also. Each one of the subclauses under subsection 3 comes under the doctrine of necessity and is therefore not supported by that. More so subclause E, which says that because it is food for the man. It's food for the man. There the question that there could be alternate forms of nutrition, which, my lord, in Qureshi 3, this honorable court said, had, my lord, had gone deeply into that subject is really not the answer. In my most respectful submission. I have my choice, my lord. I am a vegetarian. I have my choice. But there are persons, my lord, who need meat, my lord, for food, and they have been used to that. They have been used to that for centuries, and that is why, my lord, subclause E
So
under the
Jallikattu is also for centuries.
no, my lord. There is absolutely nothing to show. There is no. That's my lord. That's
Brother Roy put.
Lord,
Going on.
my lord put it on a rhetorical basis, if I may say so. I'm not, my lord, trying to put your words in your lordship's mouth. Where your lordship said, somebody wants, my lord, the hand of the very fair daughter of a noble man, and this is the only way of doing it, my lord. I don't know. He could be either completely crazy, or, my lord, he could be a very brave man.
He could be besotted, not
He
crazy.
could be besotted,
Under,
which means, my lord, another form of craziness. That's all.
under which law this animal sacrifice is prohibited for religious purpose?
No, not for religious purposes. My lord,
asking you because there is some indication that it's for animal sacrifice.
Section 28.
Animal sacrifices are not expressly permitted. But when it
Is there any prohibition?
that's not under the rules. That's under the prevention of cruelty to animals, slaughterhouse rules.
Not 28, section 28.
No, I'll come to section 58. No, that's a different. Section 58. Nothing contained in this act shall render it an offence to kill any animal in a manner required by the religion of any community. Then it must be part of an essential religious practice. What I'm saying, my lord, is that killing of an animal, if it is part of an essential religious practice, not only is it sanctioned by 28, it probably, my lord, would therefore be protected by Article 25 also. I'm saying, my lord, that Qureshi held that Bakri or sacrifice of animals, my lord, and killing of animals at the time of Bakri is not part of Article 25. Touched it, did not go deep into it, but there is no judge. There are several judgments which says that sacrifice of animals, my lord, it would not be part of an essential, it is not a part of an essential religious practice. That there are. But that is not it, my lord. If it is, my lord, I am on demurrer. Suppose it is part of an essential religious practice, it gains a protection under Article 25. If it is for food, it gains a protection under Article 21. How does a sport or a sporting event or even culture and heritage, my lord, as it is touted to be, it does not have its moorings under any one of the rights under Part 3. What I experienced as okay. Then, my lords, this is where the repugnancy really arises. The amendment, Tamil Nadu amendment, takes it completely out of the purview of the PC Act, because that's what section 11.3 says. The amendment by Tamil Nadu, both in 22, 28, section 3 defining what is a Jallikattu, section 2 defining what is a Jallikattu, 3 says the first part of 3.1 will not apply to a Jallikattu. Then 11.3, none of this will apply to Jallikattu. Then 22, then 28, taking Jallikattu completely out of the purview of the PC Act. This is where the repugnancy to the Central Act, my lord, really arises.
I said to the President. Answer is very clear. It is because there is repugnancy that there is assent to by the President.
But the assent to the President has also been independently challenged. That's a different matter. I'm not touching on that. I'm saying, my lord,
So that
is it
repugnancy go?
My lord, the first question is it repugnant? It is repugnant. Is by
Assume it is repugnant.
yes.
It is saved by the assent given by the President.
Yes. No, my lords, the question of repugnancy has also been gone into by now. Though I don't know whether the question of repugnancy.
The legislature.
It was not part of. Correct.
Legislature does not have the power to amend.
Correct.
That's why we gave the example. Suppose Parliament.
Correct. Your lordships are right.
Suppose Parliament amended it.
Yes. No, my lord.
The example is there.
Yes.
Yes.
No, Parliament did not amend this.
Supposing, we are telling you, supposing Parliament amended the law and brought in the same amendment.
Yes.
As Tamil Nadu brought in.
Yes.
Can you say it's still repugnant?
No, then the argument doesn't arise.
Therefore, what you're saying is lack of legislative power, rather lack of legislative power.
Sorry.
All of this is traced to
Sorry.
entry 17, which is in the concurrent list.
No, I'm sorry.
Prevention of cruelty to animals is in the concurrent list.
Yes.
Which means what? Both the Parliament and the state can make the laws, amend the laws. There is a law made by Parliament, the Cruelty Act. The state legislature amends it. Power is under 17.
Yes.
So how do you say power is not under 17?
No. I'm saying, my lord, I'm not on that. I'm saying that this amendment made now just is not a valid amendment because it amounts to an usurpation of the judicial power of the state. Why?
The argument.
Again, no, I'm sorry, my lord. That's not what
repugnancy at all.
No, my lord. In every case, my lord, of a repugnancy, there possibly could be, my lord, an argument of this nature also. Why I wanted to bring repugnancies for this purpose? 11.3, my lord, each subsection in 11.3, each subsection, subclause in 11.3 is rooted in some measure on some fundamental right. Not this. Not this. It cannot be on culture and heritage and definitely not a fundamental right. If it comes under Article 51GH, all right, my lord, the directive principles of state policy say that you should encourage it. But where is, my lord, the material to show that Jallikattu is part of the culture and heritage of the state from time immemorial? It is not there.
Yeah, understood you.
No, my lords, there are two judgments, my lord, which your lordships must have seen innumerable times. When it comes to, my lord, usurpation of judicial power. No, my lord, before your lordships get into that, there is one judgment on colorable legislation. Locus classicus, and the one paragraph on that, if your lordships kindly have a look at 1954 SCR 1, Gajapati Narayan Dev versus State of Orissa. But it's not part of the compilation. The list has been.
Who is the author of this judgment?
My lord, Justice Mukherjee, Justice B.K. Mukherjee.
The reference to that ECO, that US decision, just check. Chinese laundryman case. Anyway, if it's not.
No, I don't think so. No, but the nominal citation, not always. Lord, I'll check upon that your lordships are having.
No, that was one of the initial authority one.
Yes, it still remains.
The Chinese laundryman case, US Supreme Court. Anyway.
Yes. My lord, just paragraph 9. Just permit me to read paragraph 9. I'll just take 2 minutes on.
Yeah.
Para 9, my lord, I think the paragraphs are the same. I hope so, my lord, because I got a SEC copy of an SCR judgment.
Yeah.
It starts with, it may be made clear at the outset.
You have to read slowly because I am not having.
Oh, I'm sorry. I can
No,
handle
you can, I'll follow you. Please, sir.
No. My lord, it's sorry.
You'll have to tell us how it begins because SCR as
My
you.
lord, it begins by saying
No
it may
paragraph.
be made clear at the outset.
Yes. Page 10.
My lord's got it. My lord, the paragraph. SCR copies may not be paragraph.
No,
paragraphs may not be numbered.
No
Page
paragraph.
10, page 10.
But your lordship got the paragraph.
Page 10.
Yes.
And we got the para out. Please read.
It may be made clear at the outset that the doctrine of colorable legislation does not involve any question of bona fides or malefides on the part of the legislature. The whole doctrine resolves itself into the question of competence of a particular legislature to enact a particular law. If the legislature is competent to pass a particular law, the motives which impelled it to act are really irrelevant. On the other hand, if the legislature lacks competence, the question of motive does not arise at all. Whether a statute is constitutional or not is thus always a question of power. A distinction, however, exists between a legislature which is legally omnipotent like the British Parliament and the laws promulgated by it which could not be challenged on the ground of incompetence, and a legislature which enjoys only a limited or a qualified jurisdiction. If the constitution of a state distributes the legislative powers among different bodies, which have to act within their respective spheres, marked out by specific legislative entries, or if there are limitations on the legislative authority in the shape of fundamental rights, questions do arise as to whether the legislature in a particular case has or has not, in respect to the subject matter of the statute or in the method of enacting it, transgress the limits of its constitutional powers. Such transgression may be patent, manifest, or direct, but it may also be disguised, covered, and indirect, and it is to this latter class of cases that the expression colorable legislation has been applied in certain judicial pronouncements. The idea conveyed by the expression is that, although apparently a legislature in passing a statute purported to act within the limits of its powers, yet in substance and in reality, it transgressed these powers, the transgression being veiled by what appears on a proper examination to be a mere pretense or a disguise. as was said by Justice Duff, in so and so, where the lawmaking authorities have a limited or a qualified character, it may be necessary to examine with some strictness the substance of the legislation for the purpose of determining what is that the legislature is really doing. My lord, I'll stop here for a moment. But then, in other words, it is the substance of the act that is material and not merely the form or outward appearance. And the subject matter and substance is something which is beyond the powers of the legislature to legislate upon. The form in which the law is clothed would not save it from condemnation. No, my lords, please keep this judgment by your lordship's side. No, my lord, Prevention of Cruelty to Animals Act, my lord, fortunately, is under entry 17 of list 3. Entry 17 of list 3, please have a wording of it. First time that your lordships are really, I believe first time that your lordships are really concerned with the state amendment, my lord, to the Prevention of Cruelty to Animals. I'm not sure, my lord. First time. Now, my lord, in 7th schedule, entry 17 of list 3. My lord, it reads as prevention of cruelty to animals. That is how the act is also worded. A state amendment, my lord, to the entire act within itself, my lord, will be slaughtered under entry 17. A state amendment, my lords, which essentially permits Jallikattu to be taken out of the purview, my lord, of the main act. How does it, my lord, flaunt itself as an act which could come under prevention of cruelty to animals? That's a question which I asked to myself. Prevention of Cruelty to Animals Act 1960, the central act is clearly slaughtered under entry 17.
We'll give an example by way of answer to this, what you are saying. Supposing the original, that is 11.3,
yes,
A to E was already there. Assume that A to C was there and they wanted to add D and E later. Now, what is E? E permits killing of animals for the purpose of eating it.
Rooted in 21.
No, whatever it is.
Rooted in 21. That's why
we are talking about, see, the point is this. We have a division of legislative power, as you know. List 1, list 2, list 3. In the case of a state making a law, it can make it either if it falls under list 2 or it falls under list 3. Now, if it falls under list 2, then the state will have its way subject to Article 246.2, 246.3. Because it's subject to, in the case of any. In the case of a concurrent list, alone repugnancy can arise. It has been laid down.
This is one caveat.
And once there is repugnancy, it can be saved under 254.2 qua the particular state on the receipt of assent. The doctrine of colorable legislation, which you have been harping upon, relates to a conflict between a law which is made by the state legislature, pretending as if it is trying to make it under a list in list 2.
That's a classic test.
That's the test.
That's a classic test.
So if it is falling, therefore the first step you have to take is whether the law is traceable to which list. Once you find that it falls in list 3, the next thing you have to do is whether there is repugnancy. Third thing, if there is repugnancy, has President given the assent? Correct? In this case,
yes,
you should realize one more thing. The earlier
Nagaraj.
Okay. The judgment was dealing with a case of repugnancy where the state tried to put it under various state lists. It failed. This court took the view that what you're trying to do really is something which is covered by the Central Act under the Prevention Act. So impliedly the court was recognizing that if they wanted to do something of the kind which they have actually got around to doing later on in 2017, it would appropriately, properly fall within the ambit of entry 17 of list 3. So they went about doing it, and they knew that it is repugnant. Since it was repugnant, in tune with 254.2, they got assent to the president. So it's all on the, face of it, it's all very good. You may have other arguments which we are prepared to hearken to.
Can you respond? the argument, my lord, that was taken up before Nagaraj by the state were two, threefold.
Yes.
One was, my lord, that it is within the competence of the state legislature. On repugnancy, they said there is no repugnancy. This is different. Entry 17 was referred to by the court while dealing with Nagaraj also. Ultimately, my lord, the legislation is sourced to entry 17. It is not sourced to entry 14 and 15 of list 2. Though that argument was advanced, it was specifically rejected both in the main judgment as well as in the order dismissing the writ. Now, but the point is this. Lordships asked me whether, suppose a parliament had enacted this law, now that the state has done it, but hypothetically, suppose a parliament had done it, would this argument of colorable legislation, would this argument of colorable legislation apply at all? An argument of colorable legislation cannot really apply, cannot be taken up except in respect of matters which specifically come under list even regarding any parliamentary legislation. Regarding any parliamentary legislation, the question of competence can be taken up or it can be raised as an argument only when the legislation otherwise squarely falls under list 2. Otherwise, when either under list 3 or under the residuary article of list 1, it is open to the parliament to bring about any law. Well, the classic example is before Constitution was amended in 97A, entry was imported. The Finance Act was always sought to be supported. Mr. Sibyl would know that very well. Was sought to be supported with reference to the residual entry. Therefore, the parameters which your lordships would always employ in considering a colorable legislation, when it comes to a parliamentary law and when it comes to a state law, are different. My submission is that I just put what is a colorable legislation, but the argument is this, and this argument your lordships may consider. This law, which purport itself to be an amendment to the PCE Act, and PCE Act being squarely for the purpose of preventing cruelty to animals. That's the whole object of the Prevention of Cruelty to Animals Act.
That is not. Please read, take the object of that act.
Yes.
The Prevention of Cruelty Act. Please read that.
Yes.
An act unnecessary on animals.
Yes.
Next is relevant.
Yes.
And for that purpose.
Yes.
For that purpose to amend the law related to Prevention of Cruelty Act.
That's a central act.
So not for the purpose of exclusively or totally to prevent. So that is the first part. The first part says to prevent infliction of unnecessary pain or suffering of animals. To prevent.
There was an earlier.
He said the Prevention of Cruelty Act, Animals Act 1960. This was enacted for that purpose.
No, my lord, the first part of the preamble is referable to what your lordships will get it under section 11 and section 11(3). This is a manner in which, my lord, unnecessary, because preventing and unnecessary pain and suffering, your lordships will find it in every clause here, even in E, which permits slaughtering of animals. Unnecessary pain and suffering, your lordships will find it there. The Act regulates it. The Act regulates it. Lord, that is why your lordships will find
not for total prevention of
no, not that.
Because see, for the purpose of invention, to aid invention, if that is used, that will not be treated as for the purpose of cruelty.
Fair enough, my lord. Unnecessary, to prevent unnecessary pain and suffering.
That is why
what could be, my lord, is conduct of Jallikattu, which involves, my lord, as this honorable court has found, inflicting pain and suffering on bulls. Can it be treated, my lord, as something a necessary concomitant of, or can it be treated as a necessary pain or suffering that the animal may undergo? It cannot be. Sorry.
Our request. These questions have been already raised by Mr. Diwan very extensively.
Very.
And we'll call upon them.
Very.
Anything you want to add for them, added.
No, my lords, this is one.
At the same circle.
No, I'm sorry.
So, this very repugnancy submissions, views of the it's already been argued at length.
Except that, my lord, I wanted to show to your lordships 11(3) and show it that the permission that is granted under the central
11(3) has been very extensively argued by Mr. Diwan.
Not, my lord, not with reference to Article 21. Not with reference to Article 20.
Mr. Giri, our problem.
That's what I wanted to, my lord. It's only another facet of the It's another facet of the argument.
To give audience to all lawyers.
No, my lord.
The question is,
No, I'm
to
concluding.
add something to what has been
I'm
argued.
concluding in 10 minutes.
Okay.
I'm submitting, my lord, that in 11.3, why, my lord, slaughtering of animals is also governed by the provisions of the PCA Act. It's an act, my lord, to prevent cruelty of animals, prevention of cruelty to animals. But nevertheless, my lord, it also regulates the slaughtering of animals. It's prevented, that's a plenary legislation which deals with, my lord, slaughtering of animals. That is, my lord, because it is slaughtering of animals is permitted because it's food to mankind. And when it becomes part of the food, it is traceable to the man's right, my lord, under Article 21. That is why, my lord, it would gel with the general scheme of the Act, which is for the purpose of preventing cruelty to animals. The ultimate cruelty that one can inflict upon an animal is what? To slaughter it. But that is permissible because it is for food. That isn't gel with the general scheme of the Act. My submission is this. Keep that apart. Every provision in the main Act which says that slaughtering or which says, my lord, that pain and suffering, as your lordship put it, unnecessary pain and suffering apart, that there could be pain and suffering that the animals could be subjected to, including slaughtering, is because there is a justification on a higher pedestal. That is why, my lord, 11.3 cannot be found fault with. 11.3e cannot be found fault with because it is traceable to Article 21. The submission, my lord, the sequitur is this. On what higher right can, my lord, the conduct of Jallikattu be rested on? Is it culture and heritage? What is the material? One. Secondly, culture and heritage was touted before Nagaraj, before the Honorable Court in Nagaraj, as, my lord, as something which, my lord, justifies the legislation. Even in there, that's the same thing here. The format is different. No material whatsoever.
So indirectly you are saying about this is an avoidable pain.
Yes. One, it is an avoidable pain. Secondly, it is not, this conduct of Jallikattu cannot be rested on the achievement or exercise of any right which is higher to that which is already recognized, my lord, under the Prevention of Cruelty to Animals Act. You have the legislative, my lord, device by taking it completely out of the purview of the PC Act. Prevention of Cruelty to Animals Act squarely falls within entry 17 of list 3. You can't bring in an state amendment apart from the question of repugnancy. That's why, my lord, I submit. Whether could it be done, my lord, by the parliament? I'm saying, my lord, that insofar as the parliament is concerned, probably the residual entry will come and support that. But even then, insofar as the state legislature is concerned, we are concerned with that. Insofar as the state legislature is concerned, it doesn't fall, it cannot be slaughtered under entry 17 of list 3. And the legislation is therefore bad even for that reason. Yes. Every exception that is carved out under the Prevention of Corruption Act has its roots or is predicated on the exercise of some right or the preservation of some right which can be put on a higher pedestal than, my lord, the preservation of animals' rights or, my lord, avoiding unnecessary pain and suffering to an animal. Yes. This is my respectful submission. Yes. Now, my lord, on the question, my lord, I'm cutting it short. My lord, on the question of what could be the parameters, my lord, that have to be applied in relation to a validating act. My lord, I'll just give the citations and then, my lord, say what the principle is. My lord, the first one, my lord, is the original judgment of Prithvi Cotton Mills versus Brochborough Municipality, 1969, 2 SEC 283. Yes. Paragraph 4. Lord, I'm not reading it. Lords might have read it several innumerable times. 16. Lord, 69 2 SEC 283. Paragraph 4. Then, my lord, there is a detailed analysis of the same principle, my lord, reiterating what was mentioned in Prithvi Cotton in 97 1 SEC 326 paragraph.
It's the same proposition with the latest for the earliest.
Sorry,
It's the same proposition.
No. I've just given the paragraph. I'm not reading it. Therefore, I don't want to take up your lordship's time. Yes, and the last one, my lord.
Taking our time, but
no.
in practice.
Yes. But
The parent.
no, I'm not reading anything.
Yes.
The last judgment, my lord, which gives a conspect of all the earlier judgments on that point is 2003 5 SEC 23, paragraph 17 and 20 to 22. The nominal citation, judgment by Justice Rumapal, National Agriculture Cooperative versus Union of India. My lord, the test is this.
335.
One manner in which, my lord, your lord,
Repeat that page.
page, my lord, the 2003 5 SEC 23, paragraph 17, 20 to 22. My lord, the test is only this. Has the basis of the earlier judgment been removed by this amendment? Assuming that it has removed it, is it still constitutionally valid? Is it within competence of the legislature? My lord, these are the normal parameters that are my lord, applied.
Yeah.
Whenever, my lord, an act of this nature, my lord, is challenged before your lord. In my respectful submission, my lords, the finding in Nagaraj that Jallikattu inflicts cruelty upon animals is not a judgment which is predicated merely on the construction of the provisions of the act that was my lord,
Inherently cruel.
inherently. Yes. In which case, my lord, no amount of legislative engineering by bringing in a legislation which is a state amendment and getting a presidential assent is sufficient to get over it. My lord, the test is this. Had this amendment been available, my lord, to the bench, been before the bench when Nagaraj was delivered, would the judgment have been the same? The reasonings might have been diverse. But this reasoning, that Jallikattu by itself inflicts unnecessary pain and suffering on the animals, that finding would have still been the same. That cannot be removed and that has not been sought to be removed. That is not on the construction of the provisions of the Prevention of Cruelty to Animals Act alone.
Yeah.
It is, my lord, an appraisal of what the event entails. It is on an appraisal of the factual situation that was pleaded by both sides. And that is why, my lord, it is therefore elevated to the status of an adjudicated fact.
Yeah.
This, my lord, this is my respectful submission.
Thank you. Thank you. Who else is going to argue? Thank you.
My lords, can I just give the paragraph numbers and then, my lord, or if your lordships have already noted the relevant paragraphs in
Of
Nagaraj.
Yep.
Your lordships have noted.
Number of times.
3 to 56.
That's on the question of.
43 also, 43 also.
Yes,
Starting
yes.
from
You have to
43.
read.
Yes.
You have to read each and every.
My lord, the behavior of the bulls and all, my lord, your lordship
Everything
will
is
be reading it anyway. My lord, let me not restrict your lordship's appraisal of Nagaraj only to certain paragraphs your lordships have considered.
Thank you.
My lord, I'm deeply grateful to you. Lord, I hope I did not test your lordship's faith.
No, in fact, so now we'll have, who's arguing?
Very well. Grateful to you.
You are for Mr. Grover?
Lord, I am
Lord, that judgment that China, that's in paragraph 11 of the 19th.
Yes.
Lordships were referring to that.
The import, Chinese boundary man.
Para 11 of the same judgment. Professor.
Okay, so I guessed correct.
This is how we remember judgments.
Lord, I am for three writ petitioners, Lord, and the name of the organization is called FIAPO, Federation of India.
That's all right. What is the number of the petition?
Lord, numbers are 27 of 2016, 6 of 2018,
Yeah.
and 10 of 2018. Each one of them will individually challenge.
6 of 18, 10 of 18.
Each one of them individually challenge the three laws. Lord, I am going to give you on slightly different points. Mr. Shandiva did an excellent presentation, but he actually consciously gave up the issue of animal rights and whether they are amenable to protection under 21. Lord, I'm not going to argue the extreme position that they are covered as persons within the meaning of Article 21. There are lots of questions that have actually fallen from the bench. I'll attempt to answer them. So the first point will be, Lord, if I may say so, the notion of dignity in Article 21, which Nagaraja actually places a very, very important place for animals. Lord, may I just say this, Lord? Nagaraja is a judgment of seminal importance because it elevates the rights of animals from zero property.
Correct.
Lord, I want to, if your lordships will, Lord, this is because I don't want your lordships to hold that portion of Nagaraja, which Mr. Chandivan rightly, because he didn't want to argue that. It's like a batsman saying, I'll score sixes instead of fours, not because he doesn't agree with it. Lord, I want to emphasize that dignity in Nagaraja is akin to what Francis Corali Mulin did in embarking on dignity in 21. Look, let me just emphasize why. Look, prior to Francis Corali Mulin, of course, your lordships have already noticed from R.C. Cooper, Menaka Gandhi, how 1914 actually changed from just being procedure established by law to fair, just and reasonable substantive law. That's total. But what this did, Lord, it's very important to appreciate what Francis Corali Mulin did, because 21 is the classical negative covenant on the state. Please appreciate this.
Yeah.
It's essentially what is known in international law, a civil and political right. Just an addition on what is called the theory of progressive realization and non-retrogression. Classically, in international law, after the Universal Declaration of Human Rights, there is a division, partly because of political reasons, between the International Covenant on Civil and Political Rights, which are replicated in our Chapter 3, in our Constitution, Fundamental Rights, and the Economic, Social, and Cultural Rights Covenant, which are actually reflected in the Directive Principles. Both are borrowed from the UDHR. Now, my lord, 21 is a classical negative right. What did Francis Corali Mulin do? I'm very short.
Moreover, one thing, whose right you are talking about here?
I'm talking about animals' right. I told you, Lordship, I'll answer that. I'm conscious of what my Lord Justice Kumar, your Lordships, my Lord Justice Rishikesh Roy, all the five judges have put this question. So I'm going to answer that in a short summary manner, my Lord, because your Lordships have limited us in time. I'm going to argue that 21 is invocable. Not through the conduit, as Mr. Shandivan said, through the injury to the person, human being. Because, nomenclature wise, animals include human beings. We are not talking about biological definition, we are talking about a legal definition, what is personal. But let me just not emphasize this, because let us not lose the sight of the fact that Nagaraja actually made a change toward the betterment. And why, Lord? And I'm giving an example of Francis Corali Mulin because it also changed the whole notion of fundamental rights. Because prior to Francis Corali Mulin, 21 was a purely negative covenant. Procedure established by law, life and liberty cannot be taken away. After that, what happened? Moment dignity was introduced. See the power of dignity, Lord. Dignity is an elusive concept, but it is everywhere. It's everywhere. And it actually is the underlying notion of everything, of every right. Not only fundamental right. Respect, autonomy is underlying notion of all fundamentals and human rights. But it is not defined. It is not doesn't have a specific mention. Now, after Francis Corali Mulin, because we introduced dignity, what happened was, and in that case it was the access to literature, etc. What happened was, your lordships, in your lordship's jurisdiction, under 32 or 36, etc., conferred a positive right. Positive right of what? Right to food, right to environment, etc. It was unheard of, that sort of interpretation. So please appreciate one thing. When we interpret any provision of the Constitution, it has to be expansive, liberal, and it actually fundamentally changes the notion of what happens. That is also what Nagaraja did. When it introduced dignity, what did it do, Lord? It didn't say, and my Lord Justice Radhakrishnan has been very careful in actually trying to balance the rights of human beings, and my Lord Justice Joseph said, rightly, that the scheme of the PC Act and what Justice Radhakrishnan notes is, in fact, the relationship between humans animals and environment. And that is continuously evolving. Now, let me give another example. I want to emphasize this. When the Portuguese invaded Latin America, there was a debate in Portugal. They were treated as slaves. They had a high culture, better than Portugal. But they were treated as slaves. There was a debate in the Portuguese, of course, in Portugal and basically in the church. Are these Native Americans, as we call them now, entitled to be treated as human beings? And there was a particular priest who worked with Native Americans. He said they're entitled to be human beings and they have some rights. The other side said no, they're like animals, they have no rights, therefore they can be slaves. Bartolomé de las Casas argued that no, they are incipient human beings. They are like children. What I'm trying to tell you, Lordship, is after that, slavery was abolished. Things changed. Our notion of human beings has changed over centuries. Our notion of animals are changing over a period of time. So this is actually an evolutionary process where things are changing. Let's not be fixed in time space and assume that the rights that were actually accorded to animals will continue to be there for the rest of time. So today, my lord, we know certain things about animals. As Mr. Shamdivan has pointed out, they are sentient human beings. They can feel emotion. They can feel pain. They can feel heat. Therefore, they are similar to us and they have a place in nature. The place in nature is crucial to us as human beings. Their place in the environment and consequently the role they play in the environment for human beings is crucial for the survival of the human race. It's that pedestal, your lordship, will look at it, not in the pedestal of just Jallikattu. When we talk of animal rights are no longer in the species of property for human beings. That's the point of departure. So my point is, first, that your lordships look at this case not as an ordinary case. It's a case in the course of evolution of how we treat animals in the constitutional scheme of things. Now, Lord, I want to read a few passages from Nagaraja. I won't take, my Lord, Justice Joseph has put a guillotine, and I appreciate that, Lord. I wish only, Lord, my only wish is this, Lord. When the matter starts, the Lordship put a time guillotine to NIT. Otherwise, Lord, what happens is, I tell you, Lordship, very candidly, at the bar, there is a jostling for number 1 position, number 2, and number 5 or 6 don't have time. I'm not blaming anybody. But I wish your lordship will actually say everybody is going to get an hour. And then, of course, your lordships have discretion to say, no, we want to hear, because your lordships are querying.
All that we are saying is that, it need not be repetition.
I won't.
What?
Absolutely.
Otherwise,
Absolutely. If there's one word of repetition, the
if
lordship will
you
put a stop.
point, you can definitely say. Otherwise, just say you have to adopt it.
I agree with you. I agree with your lordship on that. That's why not a word of repetition from my side. Where I'm actually following the arguments, and I actually adopt the arguments of Mr. Shamdivan, Mr. Luthra, and Mr. Giri Millard. But I wanted to just say, I wanted to point out passages from Nagaraja, Millard, if your lordships will allow me, and I won't read some of them because though they have not been read, and I don't want to waste your lordship's time. Please come to Millard, para 61 of all the other passages have been read. I'm not going to read any of them, and I'm not going to read even the ones I'm relying on, just allude to them. Para 61. When we look at the rights of animals from the national and international perspective, what emerges is that every species has an inherent right to live. Now, this is a very important statement. Otherwise, if they were just properties, they would not have the right to live and shall be protected by law. Now, please note the next, subject to the exceptions provided out of necessity. Necessity is one of the doctrines which the court has adopted. So they are not entitled to full rights. Animal also have the honor and dignity, which cannot be arbitrarily deprived of. And the rights and privacy have to be respected and protected from unlawful attacks. This is, in summary, what my Lord Justice Radhakrishnan, in a seminal judgment, put forward as an advancement of the rights of animals. Then, my Lord, there is this declaration of animal welfare. I'm not going to read it, but your lordships have noted in 64, it has been read, the 5 freedoms. My only point I want to make, my Lord, is that, again, in the context of our constitutional jurisprudence, dignity is an underlying concept. Please appreciate that. So, all the 5 freedoms,
Mr. Grover,
my Lord,
the last sentence of paragraph 61.
my Lord,
Animals has also honor and dignity which cannot be arbitrarily deprived of and have to be respected and protected from unlawful attacks. Now, can it be projected that what is being done there is an unlawful attack?
in Jallikattu.
That's right.
But may I answer that later on, because this is a
sure.
very important point.
You go ahead.
I'm glad your lordship has raised it.
Just flagged it.
Yeah, I'll flag it, just put it down there. I don't forget. But I will, because I'm developing my argument, I hope in the course of that will be answered by implication, but I'll also explicitly answer that. Lord, please come to 64. What I'm pointing out, I'm not reading out the 5 freedoms. They are based on the underlying concept of dignity. So freedom from hunger and thirst, all these and more, my Lord, are based on that. Then, my Lord, please note, what my Lord Justice Radhakrishnan does is he says that, look, though we have a statute, the statute actually is in sync with this notion. Para 66. Rights guaranteed to the animals under 311, who are only statutory rights, the same have to be elevated to the status of fundamental rights. This is a wish, Milan. I'm not saying this is a law, as have been done by few countries around the world, so as to secure their honor and dignity. Honor and dignity of animals is actually the underlying theme. That is very important. Rights and freedoms guaranteed to the animals under 311 have to be read along with 51 AGH of the Constitution, which is the Magna Carta. Now, therefore, you read PCAA and 11 and 3 in sync and under fundamental rights, under directive principles. Then your lordship has seen that compassion is one aspect, humanism is the other aspect in 68, and speciesism. Now, this is important because how animal rights welfare has evolved is important. Speciesism is a concept coined by Richard Ryder in various works on the attitude to animals, like so and so, etc., defines the term of the assumption of human superiority over other creatures, leading to the exploitation of animals. So the classical view is, like it was even in Latin America, that we exploit others for our benefit. That was the view. Things are changing because we have seen how degradation, treating animals in this manner, degradation of the environment, is actually inimical to the human race. So things are evolving. We have to build new concepts. So my lords, I would request your lordship to see that in that view, in an evolutionary view. Speciesism is also described as the widespread discrimination that is practiced by man against other species. That is a prejudice or attitude of bias towards the interests of members of one species and against those members. Speciesism as a concept used to be compared with racism and sexism on the ground that those refer to discrimination tend to promote or encourage domination and exploitation of members of one group by the other. So the analogy is you exploit black people, Native American, gender, etc., and that is analogical to animals. These things have changed. Why not this? And this is more important because ultimately we have to live together. Human beings, animals, and the environment and the forest are one unison whole. That's the point. Then your lordship will come. One school of thought is that casteism, racism, and sexism are biological classifications since they are concerned with the physical characteristics such as discrimination on the ground of caste, creed, religion, color of skin, reproductive role, rather than with physical properties such as capacity for being armed. Lord, I don't know if your Lordship remembers, in the early part of the last century, there were psychologists and psychiatrists who actually propounded theories, Jensen, etc. They measured the skull of Africans and they argued that white men are mentally superior than black. And they were trying to use this is a huge thing till the 60s, till I was in university in the 70s. That was being propounded. And it was the underlying basis of Nazism. So what the analogy is very apt. That how you treated other human beings because of various factors, because you have better facilities in terms of travel, weaponry, etc., and you dominated other communities, and you try to argue that other communities are in fact inferior. Similar analytical theories were propounded for animals, and that is undergoing evolution. Now come to 70 million. We have got over those inequalities like casteism, racism, sexism, etc., through constitutional and statutory amendments like 14 to 78, etc., etc. So far as animals are concerned, Section 3 of the Act confers rights on animals and also rights under Section 11 not to be subjected to cruelty. Now, the first answer is, therefore, animals have statutory rights. So there is no question about it. The PC Act itself says that there are rights. So there are statutory rights. I'm going to develop this argument further to say they have rights which are based on dignity, which are constitutional rights. Let me develop it.
We are waiting for development now.
I'm sorry, Lord.
Come out of development. Judgment has been gone through.
No, this has not been argued at all. Please, let me.
Robert, make your submission straight away.
I will. Just let me read one paragraph. One paragraph, which has not been read to your lordships.
Robert, we can't go from the paragraph 1 to the last paragraph.
I'm not. If some
you make your submission straight away.
I'm going to argue that what is in Nagaraja is to be preserved. And I want to allude your lordship to that. Just give me 2 minutes. I will. I'm not repeating, but once your lordship has said this, I will not. I'm not going to read para 7. I only read para 71.
We can only make your
71 and 70, your lordship. We have, however, a lot of, why I'm saying this is slightly different. There are what are called non-essential activities. That's what I want to point out, because when your lordships will balance Jallikattu, the right of so-called cultural rights, which I don't think exist. I'm not going to argue that extensively. And the dignity of animals. If unnecessary pain is being foisted upon them, then your lordship will actually hold in favor of animals. So the balancing is important.
I've understood that point.
Very well. I will not read that.
That is why the other question was also put, avoidable, because it is.
Yes, your lordship was right.
Paragraph 71, it is there. It is realizing that that question was put.
Correct.
Not as if we are not.
No, I know. In fact, I noted what my Lord Justice Kumar said. But then only let me read 72. Only, sir. 72.
Gives a dignity, not essential. We have noted.
Yeah, right to life. Now, this is the 72 and we'll stop at Nagaraj.
So just give us a.
I want to. No, I will.
To complete Karnataka, you must realize that.
Outset. So, my respectful submission is right to life.
Yes.
Lord, the horse. I'm not saying animals have the same rights as human beings. This is evolving, and over a period of time, animal rights are actually increasing because we realize that they are necessary for our own survival in the environment, the role they play. Now, their right to dignity is till they are alive. Let me say that as an example, because Lord Justice Joseph is putting this point repeatedly. Killing to eat is the most cruel form of cruelty. Correct. Like putting a person to death after death penalty has been meted out to that person is also cruel. We accept it. But we say that for human beings, they are entitled to dignity throughout their life, and for human beings, even after their life. They are entitled to decent burial because of Article 21 and cultural and religious things under 25 and 29. As far as animals are concerned, and this is a point of departure and difference, they are entitled to dignity of a particular type which will come to till they are alive, but not after they are dead. So the law, because of our understanding and our relationship with animals as it is evolving, posits that we will treat them with dignity, but killing them either for food or for experimental purposes or certain exceptions, they will be killed. So that is the relationship in terms of superiority. Now, therefore, the balancing of rights is an important exercise. There the doctrine of necessity comes in. Is it necessary for us to do certain things? Or, like for example, experimentation. It's an exception. Now, let me also tell you, Lordships, that in terms of drug trials are carried on under phase 1, phase 2, phase 3. In the phase 1, animal toxicity studies are done. That's the norm. We expend animals for the purposes of our betterment. This is changing now. For example, we don't do dissection anymore on a physical animal. We have technologies which allow that to be done without actually touching an animal. But phase 1, phase 2, phase 3, phase 4 trials are on human beings. It's not as if there are no experiments on human beings. I just wanted to point that out. In fact, the drugs and cosmetics and Schedule Y make it very clear that until drug trials are carried on human beings, no drug can be approved. So just that there is an exception doesn't make animal a subordinate person. Now, what sort of rights are the animals entitled to based on the dignity that is bestowed to them? I hope I'm clear that the right to dignity is vested in animals, but it's a different type of right. It's not the dignity that we accord to human beings. What is the meaning of dignity? I teach. So the students ask, what do you mean by dignity? It could be, for example, Lord, I'm arguing. I'm just using myself as and your lordships are looking elsewhere. No, lordships are not this. Not that lordships are not this. Suppose your lordships are not listening and ignoring me. I am treated with disrespect. Then your lordship will not be treated with dignity. That's one level. The other level is to say you are a useless person. Third would be to beat up a person. So there's different levels. So what is it? First thing is that as far as animals are concerned,
You find no difficulty in making submission, but not on yourself.
very well. That is, I'm getting somewhere. I'm getting somewhere.
Full attention is on you.
No. I hope it's the judge's attention, Lord. And not other people. This is very important. I'm afraid of these things. I don't know how your lordship treat this, but this is not the.
I think the same reflection is there.
No. I am in jest, Lord. I mean, we are actually subject to now the whole world as an audience and the whole world to criticize us. Now, so, Lord, what is the level of dignity that the animals will be entitled to? First of all, they are not treated as property. So I'm trying to call out things which are different. Then they are entitled to those 5 freedoms because of dignity. I'm just giving examples, Lord, which your lordship.
Mr. Grover, so far we accept your proposition that Article 21 person are interlinked with the environment and animal.
Minus.
But from there, where do you take us to?
The next proposition,
So
Lord.
Jallikattu is concerned.
No, I'll come. Because Lord, if I had said to your lordship, let me be very candid. The Lord, this arguments are Mr. Sibbal knows better than me. There's also a psychological issue, Lord. When we put an extreme proposition, the lordship is rejected. I won't be able to argue anything else. I've learned it from Mr.
I know better than because I always put extreme propositions. That's my learned friend suggestion.
No, you taught me not to put extreme propositions.
So,
Right, my learned friend is a great teacher, Lord.
Jallikattu is concerned.
So, Lord, I want to put it quickly. This is unnecessary pain.
Only thing is, they are not, these are not voluntary action on the part of the animals, they are compelled to do it.
Yeah.
That is
One,
one.
one major,
Two, what is? the-
no, not why, because my Lord Justice Ravi was asked on the first day. They have no agency. They are not voluntary because there is no question of volition on part of animals. If they're in their own environment, like for example, the construct of willingness in human beings in law is one, consent is the other. There's no question of those constructs coming in the case of animals.
Now, the law also permits using the animals for human need.
Yes, that's an exception.
They are compelled to do involuntary acts for the benefit of humans.
Correct.
So you want to segregate the nature of benefit, that not the entertainment benefit, but physical benefit. This is what you.
I'm not doing it alone. Both Nagaraja and the PC Act does it. PC Act to a certain extent,
Yes.
that is exactly what I was trying to read in Nagaraja. This balancing exercise is by the invocation of the doctrine of necessity on the one hand and exceptions on the other. That's the balancing act.
In Nagaraja, the most important one, you read paragraph 71, but not
I
the
didn't
last,
read it.
the last sentence.
No,
The
my,
last sentence.
my lord, my
The last
lord,
sentence in paragraph 71 is very crucial.
I'll read, may I read that?
It says both anxiety and fear.
Sorry, lord.
It says, it reads this, like this. Both anxiety and fear therefore play an important role in animal suffering,
Suffering.
which is part and parcel of the events like
Correct, correct. I agree. I wanted to read that, but to deference to my lords, I didn't read it. It was time. So, my lord, what I'm saying is the overall.
So here our question is, why should it not be left to the lawmakers?
No,
And why should we take ourselves the duty of deciding to what extent we shall extend the.
no, there's no question of.
Necessary, what is not necessary, all these are all
Lord,
balancing factors.
may I answer that? The law has balanced. Now there is an introduction of an amendment.
But still, that's also law.
No, I'm not disputing that. Of course, I can't dispute it. What I'm saying is that not only your lordships have noted, completely nullifies the Parent Act. Nullifies the Parent Act, but your lordships have to interpret whether in the context of balancing of exercise, is it unnecessary? Is it an exception under the law? Those are the things that your lordships have to look into.
Should we decide what is unnecessary?
Your lordships have, because the unnecessary thing is not defined. It's what unnecessary pain is caused. Is it necessary to cause pain to the bulls because of Jallikattu, because of an imagined culture, etc., etc., or does the balance go on the other way? If it is not an exception under the law, if it is not necessary under the doctrine of necessity, your lordship will hold in our favor.
Now,
That is it.
I'm
sorry.
That we have already made out, that it's not necessary, we have noted it twice.
No, I'm answering the
No,
question.
no, yeah, since you have said, you have noted it, you move on to the next point. Otherwise, what will happen? You have taken it down, dignity. It is not essential. It is not covered by any of the essential means.
No, my Lord Justice Ravi Kumar asked me to read a portion. I
You
have to
only
be-
said if you stop it, first part of 71, you have actually brought it to our notice. The last part, you know.
Both are important. Both are important. Look, my Lord Justice Joseph. Have to be
What is the
differential to all judges. Now. I
We are
can't be.
eagerly waiting
Yeah,
for you.
now, my Lord, now my next point. Next point is, your lordships are aware that Qureshi, etc., directive principles and fundamental rights are to be in consonance, harmoniously. So 51A G
Yes.
is an important part. So when we are talking of dignity, the question will be, if your lordships accept that animals have a right to dignity, then where is it situated? Is it in 51 AG? I would say that it is situated in 21. Because that your lordships have already held. So 51 AG read with dignity have to be actually read into 22. So that is the next point.
To be read into 21.
Yes, 50 AG read into 21 is not a problem. But dignity according to human beings in 51 AG. Next, and developing on that, then Article 21, right to life. can be only realized for animals if 51 AG is complied with.
Yeah.
Therefore, compassion, etc. I've already argued on necessity and reasonable. Now, my lord, the last point, which is more difficult for me, which your lordships are waiting for me to. Now, my lord, your lordships are fully aware. Let me just develop it in a minute. My lord. It is protection against life and liberty except by procedure established. Just consider, my lord, for a moment. Today, don't we have all laws to decide how animals are to be slaughtered? So, the horse, the development of 21 before Menaka Gandhi, or even say R.C. Cooper, it was only procedure establishment and not substantive. Today, there is already a plethora of legislations which actually indicate how you can extinguish life of animals. So my point is that it can be argued reasonably that you cannot deprive a right of life of an animal without procedure establishment, not substantive. I'm not on that right now, only procedural. Even now it is there.
You're contending that the animal is a person, under Article.
No. Therefore, that is the. It's not easy to say it immediately. Let me put it that way, because when we decide, I was thinking this is because it's troubling your lordship, it's troubling me also. I have to be candid to your lordship. This is not all animals are dead with all human rights in 21. No, I'm not saying that. I've already scaled it down. Therefore, one is what Mr. Diwan said, that it is conduited to the human beings. I'm not on that. I'm saying that when you deal with animals, first they have to be respected, they have to be accorded dignity, and when their life and liberty are at stake, that dignity must come in. And I can only situate it under 21. But I'm not saying that everything under 21, which is according to human beings in our constitutional jurisprudence, will be accorded to animals. I'm not saying that. But I have to be honest with your lordship, I'm struggling on that.
So are you still saying that the animal is a person? We are again asking you.
Yes, I am saying that at one stage we'll have to say that. That depends on the evolution of various technological developments.
Today, as on today, do we have
I'll say partially, yes. I will
enough
say.
material to
Person
declare
includes
that
animal. Yes.
I'm saying you can, your lordships, in a specific sense, say that animals are entitled to dignity and life and liberty under 21, but scaled down. That's your lordship's interpretation. I'm saying that it should be accorded that.
All right. We have understood you. Yes.
Very good. No, your lordship has understood. I'm not going to. So,
collateral to 21.
I'm sorry?
Collateral to 21.
Yeah, because, please remember,
Fine,
even dignity, even privacy in the Puttaswamy case, when we were arguing it, there was a genuine difficulty among judges and lawyers. How do we situate it? And I remember Justice Zariman said, but it can be 19, it can be 21, it can be 14. How do you know it's 21? So it's not an easy task. But I am telling your lordships candidly, I am saying that your lordships, after Justice Radhakrishnan's judgment, will not go back. I won't call it non-retrogression because I'm not adding your lordship on that. The theory of progressive realization, doctrine of progressive realization, is actually applicable to what are called economic, social, and political rights, as opposed to civil and political rights. Civil and political rights are directly enforceable. As far as economic, social, they are progressively realizable. As they are realized, you can't go back. That's the only caveat I wanted to add to Mr. Diwan's argument. Now, that's my argument on 21. So I'm stopping it. The second point I want to argue is, the lordship had already seen in terms of the conflict. I'm not getting into that. I want to argue that there is no assent by the president in the manner known to law. And for that, my lord, I thought we had proper pleadings, but I must be candid again to your lordship. One sentence, we have, the draft person has actually put all the points in law, but not said that in this case, there is no assent. So, my lord, I have, with your permission, just added that line as an amendment to the petition. I have to be candid to your lordship. I can't, because this is a constitutional case, I don't want.
But tell us what
Why tell your lordship?
is
The law is very clear. The law is, like any consent, assent by the president has to be informed. If it is informed, you have to tell the president by letter or document that there is a conflict between the state law and the central law. That is, according to us, we reasonably believe it is not done. If it is not done, it is no assent in law. Simple. And there are two known, Mr. Luthra has already cited it. So we're not.
But one should presume, the presumption in evidence law is that
It is regular, 1114 acts are regularly performed.
Yes.
So Mr. Trivedi was, no, you have not contended it. It is contended except the last line that in this case is not contended. So I've taken an amendment out, not one line only. And also I've asked them to produce the documents last week. Produce the documents, show. That's the end of the matter. I don't want anything else. So that's one, judgments, lordships go on that. Just give the two judgments, but I'm not going to read them out. Look, when their turn comes, let them produce. But without production, your lordships will not be satisfied. Well, let me labor on this for a minute, Lord.
So you just give one decision which you want to try on in this.
Yes.
Just one, you don't have to multiply.
Yeah, just,
Any one which,
yeah.
any one judgment, please.
Kesar Hind, your lordship knows.
Just one case law.
Kesar Hind, my lord.
Just one case. I don't give.
Yes, my lord, 2002 8 SCC 182. Kesar Hind, your lordship knows. I'll just get your lordship the paragraph.
2008.
2008.
2008 8 SCC 182, my lord.
2008.
Presidential assets has to be informed.
What's the date?
Page.
182 Act, paras 3, 11, 14, 16 and 20.
All right, we'll see that.
So there's another decision, I'll just cite it, I'm not going to read it, it's very well. It's followed in Balwinder Singh, Balwinder Singh,
All right.
Gram Pachan.
What is the next point?
Now, the next point is that it is according to them cultural practice.
Yeah.
We had argued at the review stage that it is religious practice. That was given up and it was ruled against. Now, my lord, they have come up. They should be candid with the court. You can't one time say it's religious practice and the second time change your stance and say, no, it's not religious anymore, it's cultural. They have to be very clear. And 25 and 29 are very separate. Your lordship knows that is one. They have to affirmatively establish because they are saying as part of cultural practice, and 29 your lordships are very familiar. Sections of citizens having, I'm not reading it. And then they say that it is to promote native breeds. Now, my point is they have to affirmatively establish it. One. They have to affirmatively establish it. And actually, my lord, they can't. Once they have pleaded it's a religious practice, now they shift and they say, no, it's cultural practice. How? That's one. Secondly, my lord, even otherwise, 29 and 29, 21, all the fundamental rights have to be read harmoniously. So even let's assume that there is a cultural practice. Can it lead to the denudation or derogation of the rights in 21 with dignity of animals? It cannot, because the law is very clear on that. That just take an example of sati. There is a cultural practice of sati.
Somebody that portion is read out to us.
Yes.
We cannot have it contrary to.
Correct. Yes. There's only one judgment on that. A portion of the cultural practices which otherwise violates another fundamental right will not survive. That's the point. I'm putting it quickly. Just give the judgment.
What's your next point? Anything else?
No. Yeah. Not on that.
2000.
AR 2000 SC 2773, my lord, para 13.
Yes, what is the point?
Lord, that they have to be harmoniously construed the fundamentals. I've already argued that, and I'm just writing the judgment. Now, Lord, secondly, yeah, 2 points.
Yeah.
1 point won't take long, another point may take a slight time.
Yeah.
Lord, in any event, if your lordships agree with us on the ground that Mr. Shamdivan argued, Mr. Luthra argued, Mr. Giri argued, beholds my submissions. If the statute is held to be ultra virus, that's one thing. But a statute always overrides custom. That's the law.
Correct.
So that will not on that. Just give me that.
Overrides custom.
Yeah. Not common law, customary law. This is the state said. Now, the final point is on the issue of rules,
But
which is troubling me and troubling your lordships also.
Grover, give the citation on the.
I'm going to give you 1 minute. No, give me the. Not at me.
Yeah.
I'll just give it, you know.
Yeah, sure.
I'll in the meantime.
Last argument is on.
Last argument. No, I am not, I am going to stick to my promise. I am not, Lord, I insist.
Rules.
Yes. But please see the parent acts. It's very important to appreciate the actual rub lies in first amending the act. You know, I'm not reading the sections. And then saying nothing of the cruelty will apply to us. Now, if it is a genuine bona fide and not, I'm not on the culpable legislation. If it was really to prevent cruelty, then they would not say that none of the provisions of 11 apply. The rub is in this, that none of 11 applies. Why? I ask myself this question. Why? Because they know fully well that 11 will apply. Otherwise, why should they do it? We have to see, we have to assume that there is a purpose in 11 being amended. And 11 is being amended because they don't want 11 to apply. And that is the whole part of cruelty. And then they substitute that by mechanisms, only mechanisms which actually are to ensure, but not the core of it. The core is what is specified in section 11. But that is taken away. Then how do you prevent cruelty? You can't even have it by a mechanism. So that's the point I'm making. It's not, I'm not on colorable. Colorable is the Your Lordship has already said, if entry sandine is being used, and they say, no. This two. I'm not re-arguing. Is they have taken all can take already under to perpetuate cruelty. This is why it is to actually do breeding of native breeds of culture, but to actually escape from the liability on the Prevention of Corruption Cruelty Act with cruelty. Now, what they say, only last one, native breeds. Because this is concerned with native breeds. Now, we have come up with reports post Nagaraja. No. They are slim buffaloes. Their size replaced. They have this and that. That's a new fashion. But please appreciate that kind of evidence is not taken into account because this is vested on evidence which is biased. Because you created it for this purpose. Evidence which was the host knowing of this is important. And Tamil Nadu has its own reports on this, which I want to just point out and then stop. Now, just see in my compilation, just give the report. Not compilation, I don't want to burden your lordship. Is it in the compilation? In the convenience compilation by Mr. Justice, by the Mr. Luthra, by us, not in the convenience compilation, we have put a report of Tamil Nadu, which is document 33, volume 33. I want to just not read out, just point out the portion below, which is very important because and the sum and substance is this. And I'll stop with that because if your lordship will allow me to file written submissions later, but I don't want to.
Better that you can do.
Yeah, only one point I want to make. Just keep document 33, my lord. Page number 436, it starts, and it's of the Department of Genetic and Breeding of Tamil Nadu, and they talk of breeds. This will take only 2-3 minutes. Lord, what is it? Yeah, I'm not reading it. I'm not. Those portions, portion they're at 444, 444, 449. Now, they specifically report to the breed or species Jallikattu, which are used for Jallikattu. Specifically, their argument is that in order to preserve the species, Jallikattu is necessary. Now, in this an independent report not taking into account the litigation, there is not a word of Jallikattu to be used to perpetuate or preserve or conserve these species at all. And all other reports which are elsewhere in the convenience compilation, what they say is, why are native species dying? Last one. They are dying because these were draft animals. They were draft animals used to carry goods in the agricultural work. These agriculture work is now replaced by tractors. Therefore, they are not needed anymore. That is the reason of the native species dying. It's got nothing to do with Jallikattu. Therefore, my lords, I'll stop here because your lordships have put me on guilt.
Thank you.
Citation, Lord, that citation, my Lord Justice Roy wanted. This is Bimashia vs. Janabi, 2006, 13 SEC. Custom is overridden by statute. 2006, 13 SEC, 627. Lord, only, Lord, I'm so sorry. What do you know?
Yes, who is next?
Lord, much obliged.
Thank you. Thank you. Who else is there? I mean, we take it that Tamil Nadu side is over, going to Maharashtra.
I'm here, my lord.
So you're okay.
My apologies.
We take it beyond
I am in the very.
You are on entry 97.
No, my lords. Let me just explain my proposition, but I'm on the proposition there's no legislative competence for this law. That's one.
You are with
your writ petition.
The first writ petition in the list, my lords, today, 23 of 2016. I'm for the second petitioner, Ms. Anjali Sharma. And my learned friend wanted to point out that he is also there after me, my lords.
As far as I am concerned, my lord, I do not represent the Tamil Nadu matter at all. My lord, I am really not concerned with Jallikattu.
That's it. So we will.
I'm
Let them.
Tamil Nadu is over.
That's right. So the last person we are going to permit him from Tamil Nadu. We have had enough from Tamil Nadu. we have had spent time enough time.
I bow down, my lords, I understand.
So in your case also, you will limit your this time.
I'm going to try, my lords, to limit myself.
What we are going to do is.
I'm only going to make arguments that your lordships have not heard till now.
He is the second, representing the second petitioner.
Petitioner in a petition which is already argued.
It's not been argued, my lords.
You argued it for the first petitioner.
Nobody argued.
What is
because they are not now willing to join.
Oh.
Animal Welfare Board of India has backed out, which should tell your lordship something about what is involved in this matter, is my respectful submission. That is after having been the Millets.
What is the number? Kindly give us, please.
Writ petition 23 of 2016. I am for the second petitioner, Anjali Sharma,
No,
who is a former member.
They are not prosecuting.
Is it 2010? So as far as they are concerned, will have to be different. As petitioner is concerned, the petition will, they are not pressing it.
They
obviously.
are not pressing it, my lords. I'm correct on that.
Yes, go ahead, go ahead.
Only a minute. In this verification, we have also filed for intervention.
We'll consider hearing you. Let us see. If it is necessary, we'll hear you.
There are
Yes, go ahead, go ahead. I'm going to say from 4 to 3, we are going to see. 1 hour we are going to see next one. 1 hour.
So let's.
This is, give me the file.
Yes, I am going to be making two main submissions. First is, there is no legislative competence
Yes, no legislative competence.
to pass this amendment
Yes,
at all.
yes.
To the extent under this, to the extent that it is. First, I told your lordship, says there's no legislative competence.
Correct.
Under that, I wanted to submit that A, to the extent that this law cannot be traced to entry 17 of list 3.
Water from home. Yes, yes.
To the extent that it cannot be traced to entry 17 of list 3 or to any other entry in list 3. Presidential assent is immaterial and cannot save this Amendment Act. First proposition. Second proposition is it cannot be traced also to entry 15, either 14 or 15 of list 2.
14 or 15 on list 2.
Yes. And therefore, for these two reasons, there is no legislative competence.
Not fine.
Yes. And consequently, at best, it can fall under list 1's residuary entry, as fell from my lord the other day, and no other. Whether Parliament, my lords, your lordships had asked the question, whether Parliament,
Just tell us what elaborated.
whether Parliament will pass the amendment or not, I don't know.
Yes.
But at that stage, we look at the parliamentary amendment is my respectful submission. Now, my lords, let me explain why I say it cannot be traced to entry 17 of list 3.
Yes.
My lords, when the original law was passed in 2009, the Tamil Nadu Regulation of Jallikattu Act, it could have been argued that because it sought to regulate Jallikattu, which may cause cruelty to animals, therefore it's a law which is traceable to prevention of cruelty to animals.
Correct.
But the moment Justice Radhakrishnan, His Lordship Justice Radhakrishnan, renders a finding of fact that it is necessarily cruel to the bull to make it engage in this particular form of exhibition, performance, sport, whatever you call it. The moment this finding was rendered, any law which now seeks, my lords, to allow Jallikattu, to permit Jallikattu by allegedly making it more palatable, by making it less cruel, whatever you call it, is no longer traceable to this entry. The entry is not, and this is my respectful submission, the entry is not cruelty to animals. The entry is not performance, exhibitions, etc. of animals or competitions involving animals
Yes.
and or humans. The entry is prevention of cruelty to animals in entry 17 of list 3.
Yes.
Therefore, by definition, my lords, in my respectful submission, the pith and substance of this act and the rules, assuming that the rules are grandfathered into the act about which there is some, my lords, lifted into the act, in my respectful submission, this can never in pith and substance be relatable to entry 17 of list 3. Then, my lords, the next limb is that the entry 14 and 15, when one looks at the pith and substance, it is not related to agriculture, animal husbandry, etc. It is not related to protection, preservation, improvement of stock or veterinary practices or whatever.
So, Venugopal, see, isn't it not better that now you have ticked it off? Basically, you have flagged the issue. Depending on how they are going to defend it, you can you can elaborate it at that stage. Why we are saying is now they have to meet it. You have argued it, so we'll call upon them to meet it.
My lords, I do want to substantiate it, my lords. I want to cite a couple of cases, show your lordships how the act has to be analysed, how it has to be treated, so that he can meet it in full, my lords.
You can just give the citation so that.
No, I want to just analyse it for my lords so that your lordships see that what I'm saying, that in pith and substance, it's not a law which is relatable to these two entries, is made out.
According to you, the entry should have been perpetration of cruelty to animals.
Well, that is what His Lordship Justice Nariman has framed as the first question. If your Lordship kindly sees the questions, my lords, that were framed for placing before my learned friend, Mr. Dwivedi, had said that nobody has argued lack of legislative competence. I'm afraid that may not be correct. He may not have read my amended writ, is my respectful submission. We have raised these issues squarely, my lords, in our grounds. So, if your lordship sees the reference, the very first question is the Tamil Nadu Amendment Act referable in pith and substance to entry 17 list 3 of the 7th schedule to the Constitution of India, or does it further and perpetuate cruelty to animals? And can it therefore be said to be a measure of prevention of cruelty to animals? Is it colorable legislation which does not relate to any entry in the state list or entry 17 of the concurrent list? So this is squarely framed and before my lords, and I'm going to try to make that case good. And I won't take very long, my lords. I recognize that when your lordships meet in a configuration of 5, that your lordship's time is even more valuable than normal, my lords. But
So which are the decisions you want to tell us?
The first decision which I want to cite, my lords, is State of Rajasthan versus G. Chawla,
Citation.
1959, Supplement 3, SCR 904. I find this decision, my lords, to be is a 1959 Supplement 3, SCR 904.
Supplementary SCR.
Yeah, 3 SCR.
3 SCR.
I find it to be the most useful to understand, my lords.
Page.
90.
At 908 onwards, but I want to place it, my lords, so that your lordship
908
makes submission.
We would.
State of Rajasthan versus G. Chawla. Because case has to be applied, my lords.
Is it 904 or 908?
904 at 908 minutes is where I want to read it out to your lordships, just
So
to
if
explain.
you would, we would request you to allow us to go through that. We will undoubtedly go through that.
No, my lords, with respect, my lords.
Otherwise,
I am going to seek an opportunity, my lords, to place my case. I won't take very long, but I have to place my case, my lords.
You have cited the judgment and the point also you have very clearly articulated so that you.
I bow down, my lords,
Because
but
of the possible.
I am told,
what we intend to do.
that in the old days, Mr. Satulvar used to put one hand in his coat pocket, my lords, and state propositions to your lordships in 5 minutes to 10 minutes, and sometimes 15 minutes, and then say, that's it and leave. And your lordships would say that's more than enough for Mr. Satulvar. But I know Satulvar, my lords, I need to explain my case and make it out a little bit, my lords. That's my respectful submission. So let me please place these judgments. I need to place one more judgment also, which I'll give the citation.
What is that?
1997, 8 SCC 360, State of Bihar versus Indian Aluminium. 1997, Volume 8 SCC 360, State of Bihar versus Indian Aluminium. And then after that, I will be citing the two judgments, my lords, the Kauslaughter judgments. One is Mirzapur Moti Qureshi and the other is Mohammad Hanif Qureshi, the earlier one, to make out only this point that it cannot be traced to entry 15.
Paragraphs of Qureshi.
That, my lords, I'll give my lords tomorrow when we meet.
No, we think, see, what we intend to do is we are going to sit for 1 hour today, extra. So that we will cover up because tomorrow we are having constitution bench.
As well as?
We are having the same bench tomorrow. So we think we can devote time today. We are sitting extra 1 hour unless, you don't want to sit, you don't want to.
Let me finish tomorrow, my lords, is my respectful request.
Then let the Maharashtra lawyers start, and Tamil Nadu, whoever else is there. If you cannot finish it today, we can only.
No, so then your lordship would not hear me at all.
No, we are not saying that. Since you are insisting, we have told you we'll go through your, the paragraphs because we have understood your points.
No, you have understood the point, but not, your lordships have not understood the way in which I'm going to articulate that point based on the judgment.
You get that opportunity when the other side replies. Mr.
No, my lords.
That's what you're saying.
No, Mr. Bennett, why don't you do it straight?
Very well, let me place the
just,
judgment.
take another 5 minutes or so.
Yes.
And just finish that.
It will take a little time.
No, that's okay. Let's not debate on the time
First,
and then.
yes, your lordships are right. First, my lords, let me just show. Let me show.
Yes.
It's not for Mr. Venugopal alone, but for the others also. We intend to conclude the petitioner's second. That's what we intend to do.
It may be a little difficult, my lords, but let me try. Please see at page 137, my lords. I just want to show your lordships.
You are entitled to take the 2 minutes break, which we may need.
Very well.
We'll just come back up. So you'll also get that,
Very
idea